Welcome to part A of the lecture on case law publication. This is the first of a two-part lecture, and in this first part, we're going to give a basic introduction to the idea of formally publishing court opinions. Then we're going to see that the publication process involves several stages, and we're going to look at all of the preliminary stages in this lecture, and then in the second part, part B of the lecture, we're going to look at the final stage or permanent stage of publication, that is when the opinions appear in the hardbound case reporters. So let's start off though with a brief introduction just to make sure that we have our bearings. As a review, there are two stages of a court opinion generally. The first is that the court opinion is issued by the court. That brings the court opinion into existence. Now, this will always occur because an opinion essentially will not exist unless it's issued, or it won't have legal effect in the lawsuit in which it's issued. Now, if you'll recall, issuance of an opinion includes the courts actually authoring the opinion, and then it gets printed out, one or more of the justices sign it, and then the court clerk is instructed to file a copy of the opinion in the official file of the court relating to the lawsuit, and a copy of the opinion is then sent to all of the attorneys of record in the lawsuit and any parties that may be in the lawsuit but are not represented by attorneys. So that's issuance. So that always occurs with a court opinion. Now, the second stage would be publication. But does publication always occur? And the answer is no. Well, when does it occur? And the answer is a typical lawyer answer: it depends. So let's look at this idea of publication more closely. Publication in this context of court opinions refers to printing or otherwise reproducing copies of the opinion and distributing it in a way to make the contents accessible easily to the public. Now, that's a fairly broad definition, but what we're going to see though is it actually has a more narrow meaning when we talk about the formal or official publication of court opinions, because the end result of the publication process is that the opinion will appear in a hardbound permanent case reporter. So that's the idea of publication. But as I mentioned, not all opinions are published. And one big factor in knowing whether a case will be published is the nature or type of court that issued it. Some courts' opinions will always be published, or at least almost always. Other courts' opinions will never be published. And then there are still other courts that will have discretion on a case-by-case basis to designate the opinion as either to be published or not to be published. So let's get a general idea of which courts fall into which of these categories. So let's start with the federal courts first, and we'll start with the very top one, the U.S. Supreme Court. Pretty much, yes, its opinions are always going to be published. That is, they will wind up ultimately in the hardbound case reporters of U.S. Supreme Court opinions. Now, the intermediate courts of appeals in the federal court system, that is the United States Circuit Courts of Appeals, have discretion to designate their opinions in certain cases as either to be published or not to be published. Same goes for the federal trial courts, that is the United States district courts, which are the constitute the majority of the trial courts by far in the federal system. Again, they have discretion to designate their opinions to be published or not to be. Well, now let's look at Texas courts. Starting at the top, the Texas Supreme Court, yes, publishes its opinions. Those opinions will appear in the hardback case reporter. Now, the Texas Court of Criminal Appeals, which is the criminal equivalent of the Texas Supreme Court, they're both supreme level courts in Texas. Just remember, the Texas Supreme Court hears civil appeals, and the Texas Court of Criminal Appeals, as its name suggests, hears criminal appeals. Well, the Texas Court of Criminal Appeals has discretion to designate its opinions to be published or not to be published. Now we have 14 intermediate courts of appeals in Texas. And whether those courts have discretion to designate an opinion to be published or not to be published depends on whether the case in question is a civil case or a criminal case. If it's a civil case, then the opinion will be published. If it's a criminal case, however, the court has discretion to designate the opinion do not publish. Now, finally, the Texas trial courts never have their opinions published. Those opinions do not appear in the hardback case reporters. So, quick principle here, when it comes to Texas courts, only appellate level courts will ever have opinions appearing in the hardback case reporters. The trial courts in Texas do not. Okay, now, as I mentioned earlier, the process of publication typically involves several stages till you get to the permanent final stage. And here they are in a nutshell. First, especially if it's in the US Supreme Court, the very first stage of publication is to print the opinion in the form of a bench opinion. And again, that's very typical of the United States Supreme Court. Not all courts will issue a bench opinion. The second stage, if you're in the US Supreme Court, or the first stage, if you're in a lot of other courts, is that the opinion will be published in the form of a slip opinion. Then, multiple slip opinions will be collected, edited by the publisher, and then issued in paperback form as advance sheets. And then finally, those advance sheets are really sneak previews of the final permanent form, which is the hardback bound case reporters. So this shows a 4-stage process of publication if it's a US Supreme Court opinion. But more typically, if it's any other appellate court or some other court whose opinions are appearing for publication, then it will be a 3-stage process, beginning with the slip opinion and then ending with the permanent bound reporter. Okay, I want to walk through these stages: the bench opinion, the slip opinion, and then the advance sheets. That will bring us to the end of this lecture, and then in part B of the lecture, we will look in great detail at the permanent final stage of publication, which is the hardbound case reporters. Now, as I mentioned, a bench opinion, typically issued by the US Supreme Court, is a pamphlet version of the opinion issued immediately after the US Supreme Court announces the opinion from the bench. So it is the very first, and it is an immediate publication of that opinion in a pamphlet version. That is, it's actually available on a paper pamphlet with just that one opinion on it. Now, if it's not a unanimous opinion, which is very common, then the bench opinion publication will include not only the majority opinion, but any minority opinions, such as dissenting opinions or concurring opinions as well. So here's an example of a bench opinion by the US Supreme Court. So let's take a look at it just so you get an idea of the geography of the page. Notice in the top left-hand corner, one hint, it's very subtle, that you have a bench opinion is that it says bench opinion at the top. Now, notice right next to it, it says October term 2001. Well, I want to take a moment here to explain what this means. The word term in this context refers to the legally prescribed period in which a court may be in session. By law, courts there has to be a period of the year in which courts may be in session. Now, for the United States Supreme Court, by law, the term begins on the first Monday in October and it ends a year later on the first Monday of the following October. So it's from October to October. Now, the US Supreme Court, though, typically in the last 3 months or so of that term will recess, that is, take a break, which is one reason why there's a flurry of opinions coming out of the US Supreme Court in late June or early July. And typically, the court saves the most anticipated opinions for that last moment, and then the court recesses until the new term begins in the first Monday of October. Now, I want to contrast this word term with the idea of a court's being in session, also known as the court's sitting. The court is currently sitting. When a court is in session or sitting, that means it is actually conducting a court proceeding. So in a very narrow technical sense, the word term simply refers to the broader period of time in which a court may at various points be in session or sitting. Now, that may seem like hair splitting in terms of the difference of between term and in session or sitting, but and a lot of people will use these terms interchangeably. But for our purposes, I just want you to know that by law, the U.S. Supreme Court has an official term, which is a 1 year long, October to October, in which it may be in session, and it typically recesses and takes a break during the last 3 months. Okay, so we now know that this opinion was issued during the October term 2001. That is the term beginning in 2001. Now, we skip down here under the name Supreme Court of the United States, and we see the case name, also known as the style of the case. And that's where we are told the names of the parties. It's Toyota Motor Manufacturing Kentucky Inc. v. Williams, or versus Williams. Now below that, we're told what was the immediately lower court from which the case was appealed to the U.S. Supreme Court. And we're told that it is the United States Court of Appeals for the Sixth Circuit, Federal Intermediate Court of Appeals. Notice that it says certiorari 2. And just as a reminder, when a party wants to appeal an adverse judgment from an intermediate court of appeals in the federal system and wants to appeal that to the U.S. Supreme Court, that party has to file a petition for writ of certiorari. And if the court grants the petition, the court will then issue a writ, which is a written directive, to the immediately lower court here, the Sixth Circuit, instructing the court to send its record to the U.S. Supreme Court for review. So that means, in other words, the U.S. Supreme Court has voted to hear the case. Now, below the lower court's name, we have 3 pieces of additional information. First, we have the docket number that the U.S. Supreme Court assigned to this case when it was first filed in the form of a petition for review in the United States Supreme Court, and that is number 00-1089. 00 refers to the year of its original filing in the U.S. Supreme Court, that is 2000. And 1089 means that this case was the 1089th case filed in the Supreme Court in 2000. The second piece of information is the date in which the U.S. Supreme Court conducted oral arguments or heard oral arguments by the attorneys for the parties in the case. And that occurred on November 7th, 2001. And then finally, we are told the date that this decision was issued, and that is January 8th, 2002. Okay, so you can see also from this page, we have twice toward the top the word syllabus. And as you'll recall, a syllabus is a brief summary thumbnail sketch of the entire case that is typically placed at the beginning of an opinion. And here we have the beginning of the syllabus, the summary of the Toyota case. Now, in U.S. Supreme Court opinions, the editor of at the publisher, that is the government publishing office, that will ultimately publish the United States reports, which is the hardbound official reporters of U.S. Supreme Court opinions, will go through the opinion and prepare a fairly lengthy syllabus. And so here it begins. And a syllabi in U.S. Supreme Court opinions are typically much longer than they are in lower court opinions or in Supreme Court opinions from states, for example. Now, if you were to keep flipping the pages, you would keep reading the syllabus until it came to an end on this bench opinion. And once the syllabus is ended, then the text of the court's actual opinion would follow. Now, you see this note at the top of the screen. It says, it's right above the Supreme Court of the United States name. It's in very small print, so I've blown it up here because I want to point out a couple of things. This is a note from the editor that says that this is simply a preliminary, the first rattle out of the box in terms of publication. So it says, where it is feasible, a syllabus, or here another alternative term would be headnote, will be released as is being done in connection with this case at the time the opinion is issued. But the editor makes it clear that the syllabus that the editor has added here constitutes no part of the official opinion of the court. Instead, it is simply added for the convenience of the reader. It's like Cliff Notes. If you want to get a quick snapshot about the case to see if it's a case that you might be interested in, or if you're just wanting an overview of it, the syllabus is the place to go. But it is not part of the official opinion. You have to get past the syllabus to see the official opinion. Now, this term in parentheses on the first line of the note is headnote, and the editor here is implying that headnote is simply another term for syllabus. And be that as it may, in this course, that you are taking with me, I'm going to be using the word syllabus to refer to these brief summaries that are placed right before a court's opinion begins, instead of the word headnote. As we're going to see later in the course, headnote is a technical term that will refer to something very different. And so I'm going to use the word syllabus to refer to these summaries of the whole opinion. Okay, well, now that you know what a bench opinion is, where do you find them? Okay, if you want the bench opinion in print format, then you can obtain it from the Public Information Office of the U.S. Supreme Court. Here's the address on the slide. Or if you want it in electronic format and you want it digital, or you want it immediately sent to you by the Supreme Court digitally, as soon as it has come out, you have to subscribe to a service called Project Hermes at the U.S. Supreme Court's Information Technology or IT office. You have to subscribe if you want it to be immediately sent to you by the U.S. Supreme Court directly. Now, you might be able to still get them at another location on the web called the Legal Information Institute of Cornell Law School at www.law.cornell.edu, and then it's /SUPCT for Supreme Court. And that's free. And so that is a free source, and that will have bench opinions, or at least it used to. But in any event, the Legal Information Institute has been associated with bench opinions in the past. Okay, so that's the first stage of publication for U.S. Supreme Court opinions. Now, the second stage of publication for U.S. Supreme Court opinions, and what would normally be the first stage of publication for other courts' opinions, is the slip opinion. Now, slip opinion is a pamphlet version of the opinion that is released several days after the court has announced the opinion. So remember, the bench opinion is issued immediately after the announcement of the opinion from the bench, hence the name. A slip opinion is released several days later. Now, these are called slip opinions because originally they were issued on paper slips that were formatted in such a way that you could insert them into a book or binder until the final bound version of the opinions was ready. Now, as I mentioned, in the U.S. Supreme Court, the slip opinion is the second stage of publication after the court issued the opinion. That is, the first being the bench opinion. Now, in other appellate courts, this slip opinion is often the first stage of publication. So let's look at what a slip opinion looks like. And again, we're looking at a U.S. Supreme Court opinion. It's a different case, but you'll notice the format looks very similar to the bench opinion. So another very subtle hint that you are looking at a slip opinion is the top left-hand corner of the first page, where you see the notation slip opinion. And this particular case was issued during the term beginning October 2014. And here we have the case name. It's Obergefell et al. Versus Hodges, Director, Ohio Department of Health et al. Now, this is a very abbreviated case name or abbreviated style. And I want to just pause for a moment to point out this Latin expression et al. It appears after the name Obergefell before the V, and it also appears after the names that are stated after the V. Well, et al is the abbreviation of the Latin phrase et alia, meaning and others. So when you see the phrase et al after a name, especially in a case name, it is telling you that one of the parties is named specifically, but there are other parties that normally, for the sake of space, their names have been omitted. So it just is letting you know, okay, we've named one, Obergefell, before the V, but there are other parties on the same side as Obergefell. Similarly, after the V, you have Hodges, Director, Ohio Department of Health, followed by et al, to make it clear that Hodges is not the only party on this side of the lawsuit. And so this is very common in the case names on actual court documents. So just to let you know, this is a very common occurrence. Now, As with the bench opinion, the slip opinion begins with the syllabus that was prepared by the publisher's editor. So here it starts, and it will go on for a while. And then after the syllabus has ended, you will come to the first page of the court's official opinion. So I didn't show any of the official opinion of the bench opinion a second ago, but here in the slip opinion, I want to show you where the court's official opinion begins. And here it is. Now you'll notice at the top right-hand corner of the screen, it starts over with page 1. So the syllabus, which comes before it, has its own pagination or page numbers, but then when you get to the court's official opinion, it starts over with page 1. So you also have a hint that you are dealing with the court's official opinion, because at near the very top of the page, it says opinion of the court. It's no longer the syllabus. Now, here's another notice, similar to the note about syllabi that we saw at the top of the bench opinion earlier. Let me want to blow it up so it's easier to read, because I want to make a couple of points about what the editors here are telling us. First off, it's telling us that even though this is one of the stages of the publication of the opinion, it is not the final stage. In fact, it's telling us that the opinion could still be revised. There may be typographical errors. There may be other formal errors, that is, not substantive errors. And in fact, the editor invites readers to contact the editor in the event a reader has found a typo or other non-substantive error, so that those corrections can be made before the preliminary print goes to press. Well, what is a preliminary print? Well, that's the advance sheet. That's the third stage of publication that we're going to talk about next. But before we get to the advance sheets, I want to go back to the first page of the court's official opinion in Obergefell. Now, you will notice here that the court provides us with a much fuller case name or style. And this one looks odd, because what happened with Obergefell in this case is that there were actually 4 lawsuits that the U.S. Supreme Court granted certiorari on, but they all involved the same legal issues. And so the court consolidated these cases into one, because the court's decision on one will effectively decide the others as well. And so the court here is listing the style or case name of each of these 4 cases that have been consolidated to be addressed at the same time in this one opinion. And then finally, at the bottom, you'll see Justice Kennedy delivered the opinion of the court. That is, Justice Kennedy was the author of this opinion, and in which other justices joined. And then the actual text of Justice Kennedy's opinion begins. It says, the Constitution promises liberty to all within its reach, and so on. And then the case will continue on from there. Now, that's a slip opinion. It is a freestanding pamphlet that contains only that lawsuit's opinions. In other words, they're not collected with opinions from other lawsuits. Where do you obtain slip opinions? Now, if you want them in print format, you could go to the Public Information Office, the same place you could go for print formats of the bench opinions. Now, you can also go to the U.S. Government Publishing Office, the GPO. Its office here is in St. Louis, Missouri, but it does have a bookstore at bookstore.gpo.gov. So if you want to obtain these in print format, these are two sources. Now, there are more places though where you can access the slip opinions online, either as a PDF or digitized text. One nice thing is that the U.S. Supreme Court on its own website makes its slip opinions available for free. And I'll show you the website screen capture in just 1 second. Now, another source for the opinion is to go to the website for the federal court system generally, for all federal courts, that allows members of the public for a fee to search for lawsuits and see PDF documents of all of the documents filed by the parties in the case or the judge or the court. And that would include the opinions filed in those cases. And this website is called Public Access to Court Electronic Records. The acronym is PACER. And the website is www.pacer.gov. And I'm going to have more to say about PACER in just a minute. Now, you may also find the slip opinions at the Legal Information Institute at Cornell Law School. We mentioned that earlier in connection with bench opinions. And also, there's a free online resource called FindLaw for legal professionals at whose website address is LP for legal professionals.findlaw.com. You can obtain them there as well. Now there are 3 prominent commercial subscription services for legal research. These are very well known, especially the first 2. There's Westlaw, which of course you do have to have a subscription to access. There's LexisNexis. And then finally, there's the United States Law Week, which is published by Bloomberg Law. And but you have to have subscriptions to these 3 services. And of course, that means they're not free. Now, I want to show you here what the U.S. Supreme Court's homepage looks like. This is what it looked like at the time I created the screen capture. So it's always subject to change. But here it is, and you can see that there toward the top of the screen, there's a set of menus. One of the options is opinions, filing and rules, and so forth. Well, if you click on opinions, a drop down menu will appear, and the first option is opinions of the court. So if you click on that, then you'll be taken to a screen that looks something like this. And here you'll be able to browse opinions according to the year in which they were issued. And so, and again, these will be the slip opinions for free, accessible on the Supreme Court's own website. Now, another site I want to go back to is this PACER site. Again, this is the federal court's online system for electronic court documents. This is where you can see any documents that a party or the court itself has filed in a federal lawsuit, whether it's a past lawsuit or an ongoing one now. And again, its website is www.pacer.gov. So here's what the home page looks like. And you'll see here it says, what can we help you accomplish? Well, the first option is search for a case. Now, the way PACER works is you can enter certain search information to try to find a particular lawsuit. You can search, for example, by court. You can search by party name and so forth. So once you can pull up that particular lawsuit in the federal court system, then you can click on the name, and then it will pull up a list of all of the documents that compose the court's file. And those documents are linked in PDF. And for a fee, there's a certain fee structure, but it's not particularly onerous. You can click and open or save or print the documents that you want to. Now, one exception is if a court has ordered that a particular document be sealed, then you won't have access to that. In addition, court documents um, on Pacer have been redacted, that is, marked out or blotted out in such a way that certain personal sensitive information cannot be seen, such as social security numbers and so forth. But generally, though, otherwise you can see the full documents exactly the way they appear in the court's own file. Now, one thing to remember about Pacer, though, is that unlike Westlaw and Lexis, you can't just do word searches to search the text of any opinions themselves. What you're doing on Pacer is you are searching for lawsuits, either past or pending lawsuits. And then once you find them, then you can browse through the list of documents that have been filed in that lawsuit. But you can't word search the text of the opinions themselves. So just keep that in mind. Okay, now where do you find the slip opinions of courts other than the United States Supreme Court? Well, in electronic format, which is pretty much what you would be looking for, you normally can go to the court's own official websites. And they typically, especially in the federal court system, will have opinion search functions so that you can search to find the lawsuit that you're interested in, and then it may have a link to the court's opinion in that lawsuit. Of course, if it's a federal court, such as a federal intermediate courts of appeal or a federal district court, as well as the U.S. Supreme Court, Pacer is an option. Again, you'd have to search for the lawsuit. You're not word searching the individual opinions. You can also find other court slip opinions on the Legal Information Institute at Cornell's website. And if you have Westlaw or Lexis by subscription, then of course you can get them there as well. And on Westlaw and Lexis, you can word search. You can enter your search terms to search the actual text of the opinions. Okay, now let's get to the final preliminary stage. Sounds like an oxymoron, but this is the last stage before the final stage, and that is publication of clusters of slip opinions as advance sheets. Now, advance sheets, as we've already seen, are sometimes called preliminary prints. Sometimes they're also called advance pamphlets. So here's the way it works. Once the court has produced a certain number of slip opinions, or rather the editor of the reporter to come has produced enough slip opinions, the publisher will then collect them and add various editorial features that are going to be proprietary to that particular publisher to the opinion for the help of researchers, and then publish these opinions with these enhancements in a paperback advance sheet. And normally, by this stage, the advance sheets will contain and state the ultimate volume number, page numbers, and other editorial features that will ultimately appear in the permanent hardbound volume of the reporter. Now, it usually takes several advance sheets combined to ultimately form one hardback volume of the permanent reporter. So in essence, these advance sheets are giving you a sneak preview of what you're going to see in the hardback final volume. So here's an example of the cover of a preliminary print to the United States reports, which, as we'll see, is the official reporter of United States Supreme Court opinions. And so this is one of the advance sheets that with the others combined will form, or at least back when this was printed, would form volume 571 of the United States reports reporter. So where do you find these advance sheets? Because they are printed and disseminated by the publisher that will ultimately publish the new hardback volume to the reporters, you would need to know who the publisher of the hardback reporters are. Uh, and libraries certainly subscribe to these advance sheets, but you would need to know the publisher. Well, that's going to be a topic we will explore in part B of our slides when we look at in detail, finally, the permanent place for published opinions, and that is the hardback reporters. And so I will therefore leave us at the end of this part A of the lecture, and I look forward to seeing you in part B. Thank you for listening.